two colleagues, Jose Amanwa and Kevin Michuki.
Jose and who?
Jose Amanwa and Kevin Michuki.
Let's go.
The man behind the camera.
Maybe perhaps for guidance on which matters we are taking forum on, because this afternoon, and I believe Mr. Chibi will address it, we were served with a notice from the office of the Deputy Registrar indicating that there were several matters that were to be mentioned before you this morning, this afternoon, and last evening when we were breaking, we were to come for a ruling. Perhaps we need to have clarity that we don't have on this set of things.
We are dealing with the ruling, matter in which the ruling is supposed to be delivered now.
Then
After that, we'll deal the issues.
the nature of the case, therefore, then it means there are some advocates of voting on record for forum who did not participate or they are not participants in this particular proceedings.
Like who?
Yes, let's all have it.
Lord, lady, we have asked Labor Bureau to spend some little time with this new because it doesn't implicate it. There's no harm in the eye appearing on the record.
Is there any other concern before we read the ruling? Our ruling is ready on the consolidated petitions to the lead file being petition number E565. We have set out the structure of the ruling, but we will begin from our analysis of the issues that we think are relevant for now. This is the ruling. Having carefully considered the pleadings, submissions, and evidence of record, we consider the following issues arising for determination. One, what are the prevailing constitutional and statutory interpretation methods? Two, whether the Honorable the DCJ can assign judges pursuant to Article 165, sub-Article 4 of the Constitution. Three, other related matters. On the first issue, the Constitution is a document sui generis. It is the grundum which legally commands superiority and dominance over any other laws, and its interpretation, as of necessity, must be in a manner that all other laws bow to. The court in S versus Atchison, 1991, captured the centrality of the Constitution as follows. The Constitution of a nation is not simply a statute which mechanically defines the structure of government and the relationship between the government and the governed. It is a mirror reflecting the national soul, the identification of ideals and aspirations of a nation, the articulation of the values bonding its people and disciplining its government. The spirit and tenor of the Constitution must therefore preside and permeate the process of judicial interpretation and judicial discretion. In the matter before the court, the High Court has once again been called upon to address the issue as to whether the Honorable the Deputy Chief Justice of the Republic of Kenya, whom we refer to herein as the DCJ, can exercise the power of assigning and empaneling expanded benches of the High Court. As such, the interlink between Articles 161 sub-Article 2 and Article 163 sub-Article 1 and Article 164 sub-65 sub-Article 4 of the Constitution, as well as Section 5 of the Judicial Service Act, come into play. On that score, it is paramount to briefly look at how the Constitution and the statutes ought to be interpreted. As a starting point, the Constitution itself provides for its own theory of interpretation. That is in Article 20, Sub-Article 4, and Article 259, Sub-Article 1. Article 20, Sub-Article 4 requires courts, while interpreting the Bill of Rights, to promote the values that underlie an open and democratic society based on human dignity, equality, equity, and freedom, and the spirit, purport, and the object of the Bill of Rights. Article 259, Sub-Article 1 commands courts to interpret the Constitution in a manner that promotes its purposes, values, principles, advances, and rule of law, human rights and fundamental freedoms in the Bill of Rights, permits the development of the law, and contributes to good governance. In hailing the Constitution of Kenya as a highly transformative one, courts have over time developed various methods or canons of interpretation. In the case of David Lee and others versus Attorney General, the learned High Court judges dealt with 4